Welcome to this explainer, everyone. Today we're diving straight into some pretty dense source material to build the ultimate high-yield exam guide on civil and political rights. So, if you've got a human rights or constitutional law exam coming up, you're in exactly the right place.
Okay, let's just get right into it. We're going to take this massive, sometimes overwhelming topic and break down exactly what you need to crush your essays and multiple choice questions. We're turning all that heavy legal theory into clear, testable, and honestly, pretty interesting concepts. Here's our roadmap for today. 1. Foundations of civil rights. 2. Characteristics of negative rights. 3. Key ICCPR articles explained. 4. International enforcement and limits. 5. The Indian constitutional matrix. And 6. Landmark civil rights cases. Section 1. Foundations of civil rights. Before human rights were, formal constitutional text, Enlightenment thinkers, especially John Locke, argued that we all have inherent natural rights to life, liberty, and a state. These aren't gifts from the government. They existed way before any political state was even formed. You didn't just surrender them when you joined society. In fact, the government was literally created to protect them. And these ideas didn't just sit around in dusty books. They sparked massive historical upheavals, moving from the Magna Carta to the English Bill of Rights, the American Declaration of Independence, and the French Declaration of the Rights of Man. Section 2. Characteristics of negative rights. Now, the source material draws this absolutely brilliant distinction about how individuals relate to the government. Civil and political rights, they're categorized as negative rights. Now, what does that mean? It means they demand immediate state forbearance. The state doesn't need to be super wealthy or build massive long-term infrastructure to just stop arbitrary arrests, right? They don't need a massive budget to not torture someone. Because they don't require heavy resources, they are immediately realizable and strictly justiciable in court. So, here is a massive exam tip. Write this exact definition down, word for word. Negative rights impose a strict legal duty of inaction or forbearance upon the state. It draws a hard boundary around the individual. If you're writing an essay intro on civil rights, this sentence is foundational. It immediately shows the examiner you actually understand the mechanics of these liberties. Section 3. Key ICCPR articles explained. To make sense of the binding 1966 ICCPR treaty, it really helps to group these core articles into manageable buckets. Bucket number 1 strictly safeguards physical and mental integrity. We have Article 6, the supreme right to life. Article 7 absolutely bans torture and forced medical experiments. And Article 8 prohibits slavery and compulsory labor. Basically, these are your absolute non-negotiable baseline protections against violent state overreach. Moving on to our second bucket, this one is all about procedural safety blocks. Article 9 protects you from arbitrary arrest. Article 11 is super specific. You literally cannot be imprisoned just because you couldn't pay a civil contract debt. Then there's Article 14, which is a massive one for procedural justice. Fair trial, presumption of innocence, no double jeopardy. Article 15 bans retroactive criminal laws, meaning they can't punish you for something that wasn't a crime when you did it. And Article 17 protects your privacy, your family, and your home. And our final bucket protects those foundational democratic freedoms. Article 18 covers your conscience and religion. Article 19 secures freedom of expression. But interestingly, Article 20 places a mandatory restriction on expression. States actually have to ban war propaganda and hate speech. Article 25 secures political rights, like voting. And finally, Article 27 explicitly guarantees that ethnic and linguistic minorities get to enjoy their own culture and language. Section 4. International enforcement and limits. Now, you might be wondering, what happens during a severe national emergency or a war? Can the state just hit pause and suspend all these rights? Well, Article 4 of the ICCPR does allow for temporary suspension of certain rights during extreme emergencies. But, and this is a huge but, it builds an absolute humanitarian boundary. The ICCPR strictly states that some rights can never, ever be touched. And to monitor all this, the UN set up the Human Rights Committee, which is a group of 18 independent legal experts who keep an eye on global compliance. Okay, grab your notes, because examiners absolutely love testing this in the multiple choice section. You need to know exactly which rights are non-derogatable, meaning they cannot be suspended, ever. That's Articles 6, 7, 8, 11, 15, 16, and 18. Life, torture, slavery, debt imprisonment, retroactive crimes, legal personality, and religion. No matter the crisis, these 7 are locked in, for sure. Section 5.
Indian Constitutional Matrix.
The source material highlights something really brilliant about the framers of the Indian Constitution here. They took these first-generation civil and political rights and wove them directly into Part 3 of the Constitution as fundamental rights. And crucially, they made them immediately justiciable. This means if the state messes with your liberties, you don't have to wait around. Under Article 32, you can go straight to the Supreme Court. And under Article 226, you can hit up the high courts for immediate writ remedies, like habeas corpus.
But, the real expansion happened inside the courtrooms. Through the doctrine of judicial activism, Indian courts realized that civil liberties don't just exist in a vacuum. They dynamically expanded human rights by taking the positive social and economic safety goals of Part 4, the directive principles, and essentially reading them directly into those justiciable protections of Part 3. It's a really seamless blend.
Section 6, Landmark Civil Rights Cases.
First up on our landmark list is Maneka Gandhi. Just imagine a journalist having her passport impounded in the public interest without a single hearing or even a written reason. That was the fact pattern. The core issue was whether the right to travel abroad is part of personal liberty under Article 21, and if the government can just restrict it without natural justice. The judgment here was a total watershed moment. The court ruled that personal liberty has the widest possible amplitude. And crucially, the procedure established by law can't just be any formal process. It literally has to be just, fair, and reasonable. This permanently integrated substantive due process into Indian law.
Next is the really tragic case of D.K. Basu, stemming from a public interest litigation detailing horrific deaths and torture in police custody. The Supreme Court had to ask, how do we actually protect people's physical security under Article 21? The result was 11 strict, mandatory procedural guidelines for all arrests. We're talking clear officer identification, mandatory medical exams every 48 hours, the whole shebang. This case is your definitive go-to authority for essays on custodial violence.
Our third case, PUCL, deals with something super relatable today: unregulated phone tapping. The court looked at the widespread wiretapping of activists under the Indian Telegraph Act, asking if this surveillance violated free speech and privacy. The Supreme Court said yes. Telephonic conversations are an intimate part of private life. Arbitrary tapping directly violates the right to privacy under Article 21. It can only happen under strict statutory safeguards during grave public emergencies. PUCL is direct enforcement of ICCPR Article 17 against text surveillance. Finally, the modern giant, K.S. Puttaswamy. This started as a challenge to the massive Aadhaar biometric program. The central issue, is privacy actually a fundamental right, even though the word privacy isn't explicitly written in Part 3? A historic 9-judge bench unanimously said, yes, absolutely. Privacy is a natural, unalienable entitlement flowing from human dignity and Article 21. Most importantly for your exams, they created a 3-fold test for state invasion of privacy: legality, need, and proportionality. Okay, make sure you get this cheat sheet down in your notes because it will organize your essay frameworks perfectly. Procedural fairness, boom, Maneka Gandhi. Police powers, D.K. Basu. Surveillance and data, you're using PUCL and Puttaswamy. If you tie these cases back to the ICCPR articles we just covered, you are setting yourself up for top marks.
As we wrap up this explainer, I want to leave you with a final, provocative thought, something you can maybe even use as a killer conclusion in your own essays. If privacy is indeed a natural, unalienable entitlement, how will this living constitutional shield adapt to tomorrow's unknown, highly advanced state surveillance technologies? Civil and political rights aren't just history, guys. They are an active, ongoing battle for human dignity. Keep studying, master these frameworks, and good luck on the exam.